Hello, my name is Kaylee Carrillo, and today we will be discussing case studies of the Innocence Project. The Innocence Project was founded in 1992 by Barry Scheck and Peter Neufeld. They met when they were public defenders at the Bronx Legal Aid Society. The Innocence Project started as a legal clinic at Benjamin N. Cardoso School of Law, where they studied DNA methods with their team while working on the Marion Coakley case in the 1980s. Coakley had been wrongly convicted of rape and robbery. But Barry Scheck stated, "We knew that with this new DNA technology would not only prove people guilty, but also prove people innocent." From there, the organization grew and it became an independent nonprofit in 2004. A lot of things have changed from the beginning and now. The first DNA exoneration took place in 1989. The Innocence Project started with humble beginnings with 3 lawyers on staff, 20 Cardozo Law School clinic students trained in 1992, 10 exonerations by 1992, and 0 states with post-conviction DNA statutes in 1992. But now there have been 375 DNA exonerations, 50 states with access to post-conviction DNA testing, 25 states that record interrogations, and 20 states with improved eyewitness procedures. This graph shows the errors that contribute to the convictions. 69% involved eyewitness misidentification, 43% involved misapplication of forensic science, 29% involved false confessions, and 17% involved informants. To date, there have been 375 exonerees, as stated previously, and this shows the demographics of these people. Norman Atkins, who was wrongly charged in 1988 for robbery and rape and was sentenced to 45 years but served 12 years and was released in 2000. During the investigation and trial, the victim was taken to the hospital for vaginal swabs, and also they collected her clothing where there were seminal stains. She did not identify Atkins until she saw a wanted poster for unrelated charges and was then shown a photo lineup where she identified Atkins. A witness who worked at the store next to where the incident occurred was also shown the wanted poster, as seen on screen, and told authorities he had been in her store earlier that day. Further evidence presented by the prosecution included testimony from a criminalist who testified the semen was from someone with blood type A and PGM 2+1+, which is consistent with Atkins typing. However, both the victim and Atkins were A secretors. The analyst testified, "The activity that I detected could have come from the victim herself, or it could have come from a combination of individuals with those blood types." The analyst further explained that the combination of people who are A secretors and PGM type 2+1+ come out to about 6.1% of the general white population and about 4.4% of African Americans. But during his post-conviction investigation, his case was accepted in 1993, and the sweater and swabs were located in 1995. DNA testing was granted in 1999. The Forensic Science Associates conducted DNA testing on 3 separate areas of the sweater, and in all 3, the results consistently excluded Atkins. So once he was released from prison, he enrolled in psychology courses. He got married to Machara Hoog, and he and his wife founded Life Intervention for Exonerees, which is a nonprofit organization that presents the wrongfully convicted with welcome back baskets. Atkins also pursued a law degree in California Western School of Law in 2009. Study will focus on Ralph Armstrong, who served 28 years in Wisconsin prison for a murder before he was exonerated in 2009 based on evidence that a prosecutor had deliberately withheld evidence of his innocence. On June 24, 1980, Charis Camps, a 19-year-old student from the University of Wisconsin, was strangled to death in her apartment. She was found naked and face down in her apartment with a bathrobe belt across her back. Charis had drunk alcohol and used drugs with Ralph Armstrong and his brother Steve, and a few others the night she died. Ralph confessed to using cocaine with her and that they were in her apartment alone for a short time around 9:15 p.m. before joining other friends. Police discovered that Armstrong owed Camp's boyfriend $400, and witnesses say they saw him hand her cash the night of her murder. The identification. A neighbor of Camp told police he saw a lean, muscular man with long dark hair pull up in a black and white vehicle around 12:30 a.m., and the man ran in and out of the building 3 times before disappearing. Police arranged for the witness to be hypnotized. The detective claims the witness did not see photos of Armstrong or his car, but the witness disagreed, saying he saw photos in the hypnosis room. At first, the witness stated that the perpetrator was 5'3" to 5'5", but changed the height to 6 feet. Police then conducted a pseudo reenactment lineup near the crime scene with Armstrong and 4 participants who were officers wearing wigs. Armstrong's attorney felt this was a rigged lineup. The witness identified Armstrong but also noted that other participants were wearing wigs. So during the trial, a forensic analyst testified that the head hairs collected from the bathrobe belt and sink were consistent or similar to Armstrong's hair. She also identified several pubic and head hairs that she claimed were not from Camp or Armstrong. Prosecutors exaggerated the importance of the hairs, saying 2 of the defendant's hairs were on his robe. The forensic analyst also found a positive reading for the presence of chemicals in human blood on several of Armstrong's fingers and toes, but wasn't able to determine any blood characteristics. This was also exaggerated by the prosecution. The semen and bathrobe came from a type A secretor, which Armstrong was. Despite his defense challenging the timeline of the night, eyewitness identification, and forensic science, he was convicted and sentenced to life in prison plus 16 years. So during post-conviction appeals, in 2001, DNA testing excluded Armstrong and the boyfriend, and it was found that the semen stain used against Armstrong was actually the victim's boyfriend. Due to this new evidence, the Wisconsin Supreme Court overturned his conviction in 2005 and he was granted a new trial. While a new trial was pending, a twist of events had occurred. A woman testified that she had called Dane Court Assistant District John Norsetter attorney in 1995 to report that Armstrong's brother Steve confessed that he committed the murder, and that he feared Ralph would be exonerated by DNA and come after him if Ralph found out. However, Norsetter did not report this evidence to the defense attorneys and did not pursue the lead. Steve then disappeared after the crime and never contacted his brother. Steve died in 2005. But in 2006, mitochondrial tests from the hairs of the crime scene excluded Ralph Armstrong, but Norsetter secretly ordered more DNA tests, including YSTR tests, which used up the biological evidence. However, the defense was not aware of the woman's 1995 call until 2007. The defense argued that Norsetter ordered Y-DNA tests in order to get conviction against Ralph, even if his brother's indistinguishable Y-DNA was found. Norsetter then admitted under oath about receiving the call, but he felt the information wasn't credible enough to pursue the lead. Armstrong's do-right processes had been compromised, so the state circuit judge dismissed the case in 2009. In conclusion, there is much work to be done to help with wrongful convictions. Some state courts do not recognize discredited scientific evidence as new evidence of a wrongful conviction, but there have been some states who have made more laws to help these people. California enacted a law in 2014 that allows convicted people to seek relief based on flawed forensic evidence used in their sentencing. And in 2013, Texas was the first state to pass a law allowing people to challenge their convictions based on new or discredited scientific evidence. Time is priceless and can never be monetarily be compensated for the individuals who spent years and decades in prison. But hopefully we can help those who have not found justice for themselves. Thank you. Oh, and here's the works cited.